Here are the 5 most common business entities for startups, plus an extra 2. This video is for educational purposes only. If you can afford to get an attorney, please get one and let them review your individual case. Now, if you wanted to start a business, you could literally just start. You could get the equipment, get customers, start providing whatever service or good. If you did this, however, this would be called a sole proprietorship. It simply just means a single business person. Now, if you chose this path, you'd be taxed just like you're taxed while working for someone else. So you'll pay your taxes, whatever your state and federal taxes are, and whatever income you're making from your customers will literally just be like income you would have made if you were working for someone else. Now, let's say when you're starting out, however, you decided that you wanted a partner. So you called one of your buddies up and you said, I have this great idea for a business and I want you to work with me. Your partner says, good, let's do it. And you guys put together some funds and some resources and you start your business. A partnership is very similar to a sole proprietorship in that you pay taxes just like you would have paid if you were working for someone else. That means you'll pay taxes to your state and to the federal government, to the IRS. Now, let's say business has gone well and you want to bring on a third partner, except this third partner doesn't want to actually work in the business. They'd rather just invest some money into it. There is a problem here, right? Because one way they could do this is simply to loan you the funds. But if they loan you the funds, you'll just pay them back the funds plus interest. No, what they really want is to be able to share in the profit and loss by implication of the business. The problem with a normal partnership called a general partnership, if there's a problem in the business faces a lawsuit or breaks the law in any other way, each individual partner is held liable for the debts and wrongs of the business. It's like if you broke the law in a particular way or got into a dispute, you would be sued, right? Not another entity. Now, because there's no other formal entity in front of the state, you are the only entity that can be sued. So if you're a sole proprietor or your partner, when your partnership gets sued or your business gets sued, you get sued as well directly. And this third-party investor is not going to be involved in the day-to-day running of the business. All he wants to do is put in some money and let the profit come out. So what's the solution? Well, the states decided that one way they could protect that third partner, who will likely not be doing much in the business, is to create what is called a limited partnership. For the limited partnership, the third partner, the investor, has what is called limited liability, meaning that they are only responsible for the portion of the business that they actually own. So they can only lose what they've invested into the business. They themselves cannot be held personally liable for the debts of the business or for any tort, meaning any laws broken or any disputes that the business comes in with someone else. Now, the downside of a limited partnership, however, is that the other two partners can be held personally liable for this. And this is where limited liability companies become very important. Now, a limited liability company takes the upsides of a limited partnership, the upsides that the limited partner has, and it applies it to everyone. But in this case, they're called members. So if you form an LLC, you have the same protections that a limited partner has. If someone sues the business, they're suing the business entity because now an entity actually exists, which brings us to the next point. For this entity to exist, you have to file some paperwork with your Secretary of State or whatever government body is in charge of this in your state. Once this paperwork is filed either for a limited partnership or for an LLC, then this limited liability applies to you. Now, an LLC is also good because you still get taxed the same way. When the profit of the business comes in, and you take your share of the profit, that share is then taxed to you as you would have been taxed if you were working for another corporation, right? It's direct taxation. Why do I bring this up? Because of the fifth type of business entity, the corporation. Now, a corporation is taxed differently. It's taxed on 2 levels. The corporation in of itself, the entity, is taxed. And then you, the individual shareholder, in this case, you own the business. You, the shareholder, are also taxed when the profits of the business are distributed to all the shareholders. You get taxed as well. So the downside of a corporation is that there is double taxation. You get taxed on 2 levels. You don't have that with an LLC. But why do people still incorporate? The structure of a corporation allows it to grow large. Any number of people can own shares in a corporation. You can also sell your shares to someone else very flexibly. And the regulations of corporations allow them to be easily traded, especially when they have an IPO. With a corporation, however, the shareholders that actually own the company are different from the board. So the shareholders come together and they elect a certain number of people to sit on a board to watch over the corporation. Now, the board is actually the authority holding body, the structure. So the board of directors has all the power, and then they appoint officers that can serve in their stead. Now, in small corporations, what usually happens is the shareholders end up also being the board of directors and many times also end up being the officers. As the corporation grows larger, however, there's usually a bigger distinction between the board of directors, the shareholders, and the officers. Now, the extra two I mentioned in the beginning are actually also corporations. So the corporation I just described is called a C Corp, a C corporation. Many states also have what they call an S Corp. An S Corp is basically a C Corp, but it allows the singular taxation to flow through. So instead of taxing the corporate entity and also taxing the shareholders are taxed directly. So you have all the advantages of having a regular corporation, but then you have the disadvantage of the flow through tax. Now, there's still one more kind of corporation that's a lot more rare, but you now have many large companies beginning to do this, especially in the last 5 years or so. This is a B Corp, a benefit corporation. Now, this corporation is just like a normal C Corp. The difference is that in their articles of incorporation, they commit to do more than profit seek. So a corporation, when it's set up, is set up for the benefits of the shareholders. So when the officers are serving, they're serving to try to maximize the value of the shares of the shareholders. Now, a B Corp says, let's not do it that way. Let's include something else that's important, social factors like the environment, third party stakeholders that may not be shareholders in the business, but whatever the business does affects them in particular ways. To considering these people in their decisions. Now, they just don't do this on paper. They actually have to file annual reports called annual benefit reports that are submitted to the shareholders, to the board, and many times also to the Secretary of State of whatever state you're incorporated in. And this basically shows the decisions that were made, the things that were considered, and the fact that they considered these third-party factors like the environment and third-party stakeholders. So these are the main 5 types of corporations, plus 2. The S Corp and the B Corp are more rare, but the other 5 are pretty common. I hope you found this video helpful. Again, if you can afford it, get an attorney to take a look at what business entity is best for you. Thank you guys for watching, and I'll see you guys in the next one. Bye.